Welcome back, Focus Learners. Today, we're jumping right into an epic legal clash. I mean, literally the heavyweight title fight of tort law that every single law student absolutely has to master. We're talking about the duty of care and negligence, and specifically the legendary debate between Chief Justice Cardozo and Justice Andrews. This stuff fundamentally shapes how liability works in our society, so getting a solid grip on it is basically your master key to unlocking tort law. Okay, let's dive straight into our roadmap for this explainer. We'll start by breaking down the general duty of care, then explore Cardozo's zone of danger. Contrast that with Andrews' world at large, test your knowledge with a little Q&A, and wrap it all up with the exact playbook you need to ace your torts essay. Section 1. The duty of care, the absolute gateway to negligence. Before we can even think about breaching a standard or calculating damages, we gotta clear the very first hurdle. Did a legal duty actually exist? The duty of care is, simply put, a legal requirement to avoid causing an unreasonable risk of harm to others. Think of it kind of like, well, like a sci-fi force field. As we move through the world, we're constantly emitting these risk rays. And, the more dangerous our activity is, like driving a speeding car versus just sitting quietly on a park bench, the further those risk rays extend. That means we're legally obligated to take more precautions to dampen them. But the real question is, to whom exactly do we owe this duty? That brings us to Section 2, Cardozo and the Zone of Danger, which is the majority view on relational duty. This whole approach stems from arguably the most famous torts case in American history, Palsgraf v. Long Island Railroad. In his opinion, Chief Justice Cardozo famously wrote, "Proof of negligence in the air, so to speak, will not do." I absolutely love that phrasing because it completely grounds the whole concept. He's essentially saying, hey, negligence isn't just some abstract, free-floating bad behavior. You can't just act carelessly and boom, you're automatically liable to literally everyone on the planet. Instead, Cardozo established that duty is a purely relational concept. So what does that actually mean for us? Well, it means your careless conduct has to be a wrong relative to the specific complaining plaintiff. A defendant only owes a duty of care to a foreseeable victim. If you couldn't reasonably foresee injuring that specific person, then you owe them zero duty. End of story. Now, what's really interesting is exactly how Cardozo defines that foreseeability. He came up with this brilliant concept called the zone of danger. This is this specific physical area where a reasonable person could anticipate that their carelessness might cause foreseeable harm. If a plaintiff happens to be standing inside that zone, they're owed a duty. Outside of it, no duty whatsoever. Let's look at the actual Palsgraf facts that led him to this conclusion. Train guards were helping a passenger, and that passenger dropped a package. Now, this package appeared totally harmless. It was just wrapped up in some newspaper. The guards had absolutely no notice it was packed with fireworks. Meanwhile, our plaintiff, Helen Palsgraf, was standing way, way down at the completely opposite end of the platform. So because the guards couldn't foresee an explosion and definitely couldn't foresee harming someone standing so incredibly far away, she was deemed an unforeseeable plaintiff. The result was no legal duty. This rule acts like a giant filter, basically allowing judges to dismiss cases as a matter of law long before a jury ever even sees them. Which leads us to Section 3, Andrews and the world at large, the dissenting minority view. While Cardozo's view won out and became the majority rule across most jurisdictions, Justice Andrews offered this sweeping, completely different philosophical take on our responsibilities. He wrote in his dissent, "Everyone owes to the world at large the duty of refraining from those acts that may unreasonably threaten the safety of others." Notice the massive contrast here. Cardozo says duty is strictly limited to that foreseeable person in the zone of danger. Andrews, on the other hand, says no way. If you commit an inherently unreasonable act, you've wronged society itself. You owe a duty to anyone and everyone who is actually injured by it, no matter how far away they might be. Let's put these two head to head. On one side, we've got Cardozo representing the majority. Duty is owed only to foreseeable plaintiffs inside the zone of danger. On the flip side, we have Andrews with the minority view. Duty is owed to everyone actually harmed. But wait, Andrews wasn't suggesting liability should just be completely infinite. He just believed we shouldn't be placing the limit at the initial duty stage. Instead, for Andrews, proximate cause is the ultimate break on liability. He expands the initial duty to the world at large, sure, but he relies on the jury to use proximate cause, looking at natural sequences and how remote the harm is, to cut off liability if the outcome is just way too bizarre or disconnected from that original negligent act. Moving to Section 4, Q&A. Let's do a quick Socratic pivot to test your knowledge. Okay, time to see how these rules actually apply in practice. Imagine this scenario. A driver carelessly blows through a stop sign and directly hits a pedestrian who's walking right there in the crosswalk. Is a duty owed to that pedestrian under the Cardozo approach? Give it a quick second. Think about that zone of danger. And this brilliantly illustrates how the majority rule functions. The answer is definitely yes. By running that stop sign, the driver creates an immediate zone of risk right smack in the intersection. The pedestrian is physically inside that danger zone. Because of that, they are a completely foreseeable plaintiff, and the driver absolutely owes them a duty of care. Let's turn up the heat with a tougher one. What if that exact same driver crashes at the intersection, but it sets off this wild chain reaction? Like, a truck swerves to avoid it, takes out a power pole, the power grid goes out, and a mile away, someone falls down a pitch-black staircase. Under the Andrews approach, is a duty owed to that person falling down the stairs a full mile away? Believe it or not, the answer here is also yes. Under Andrews, duty is owed to the world at large for unreasonable acts. Running the stop sign was negligent, so the driver owed a duty to anyone injured as a natural result. But, and this is a huge but, the driver isn't necessarily paying damages here. Remember, under Andrews, duty isn't the barrier for distant plaintiffs. Proximate cause is. The defendant's lawyer would argue straight to the jury that the harm a mile away was simply too remote to be the proximate cause. Finally, Section 5. Acing your torts essay, the student playbook. Let's bring this all together now. Understanding the philosophy is awesome, but you need to know exactly how to structure this on an exam to scoop up maximum points. Here is your fail-proof IRAC structure for this. Step 1. Clearly state the general duty rule that everyone has to act as a reasonably prudent person under the circumstances. Step 2. Immediately apply Cardozo's majority view. You gotta analyze whether the plaintiff was foreseeable and physically in that zone of danger. Step 3. Apply Andrews' minority view, explaining his whole duty to the world at large concept. And Step 4, seamlessly transition into your proximate cause analysis, making sure to note how it acts as the actual liability limit for Andrews. Now, a few pro tips to avoid common student pitfalls. Always analyze Cardozo before Andrews. It's the majority rule, it's the primary filter, so put it first. Next, really drill down on the procedural difference, because professors absolutely love testing this. Duty is a question of law, which means it's determined exclusively by the judge. Proximate cause, that's a question of fact, which is left to the jury. Cardozo uses duty to allow judges to toss out remote cases early on. Andrews relies on proximate cause, trusting the jury to figure out where the liability should rightfully end. Nailing that distinction is absolutely key to getting an A. Which brings us to a final, pretty provocative thought to chew on. As you dive deeper into your legal journey, ask yourself, should our legal duty really be restricted only to the specific, foreseeable harms we can vividly imagine in our immediate zone of danger? Or, if we choose to act carelessly, should we bear the heavy responsibility for every single unforeseen ripple our negligence causes out in the world at large? It's a massive question that courts have debated for a century, and now you're fully equipped to answer it yourself. Thanks so much for joining me on this explainer. Keep studying hard, and I'll see you next time.